The landlord who threatened to evict us 2 weeks after we called the police withdrew that threat 8 days after my attorney's letter landed on his desk. He installed a lockable cover on the attic hatch within 30 days, the exact thing we had been asking him to address for months. And the mistake that made all of that inevitable, he sent the eviction threat in a text message, the day after we filed a police report. I had spent 6 years working at a law firm. I know what a time-stamped text message is worth in a retaliatory eviction case. If your landlord threatened to kick you out because you called the police about a safety problem in your building, would you know what to do? Stay with me to the end, because by the time this video is over, you will have the statute number, the protection window, and the exact words to send back. Here are 3 moments you are going to see in this video. First, the night I stood in my kitchen, pulled up the Texas property code on my phone, read section 92331 3 times, and understood that my landlord had handed me a legal defense with his own text message. Second, the building inspector's report, the one that took a landlord's dismissal of old infrastructure and turned it into a compliance notice that required him to fix the exact thing he had been ignoring for months. Third, the text my attorney sent me 8 days after she mailed the letter. She said, "They withdrew, no formal eviction, your tenancy is secure. I am 31 years old. I live with my younger sister Mara in a top-floor apartment in a complex outside Fort Worth, Texas. I have been in this apartment for 4 years. Mara joined me 2 years ago after finishing school and finding work in the area. We are not dramatic people. That is the thing I need you to understand before anything else. I worked for 6 years as an office manager at a law firm, the kind of job that trains you to read documents carefully, to distinguish between what a thing says and what someone claims it says, and to understand that paper trails are not bureaucracy, they are evidence. From there, I moved into medical billing, numbers and records and precision. Mara is a physical therapist. She is practical and measured and the last person in any room to jump to a conclusion. We are not the kind of people who imagine problems or who report things for effect. We are the kind of people who, when something is wrong, document it and then figure out what the law says about it. That combination, documentation plus statute, is exactly what Mr. Vickers did not account for when he sent that text. Mr. Vickers has owned the complex for about 15 years. I know this from the property records I pulled. He has a reputation in the building, not a good one, among the longer-term residents. He is known for one thing in particular, a phrase he deploys whenever a tenant raises a concern that inconveniences him. The phrase is, "I know the law." He says it as a conversation stopper, as a signal that the discussion is over and his interpretation of the situation is the correct one. His symbol of authority is tenure, 15 years of owning these buildings, knowing the property, knowing the management company, knowing which tenants can be managed and which ones cannot. His power is the lease over your head. His motivation is never the problem itself. It is always the same thing, maintaining the version of events in which he is the reasonable one and the tenant is the problem. The phrase "I know the law" is not actually information. It is a bet that you do not know the law and are therefore unable to challenge the claim. What Mr. Vickers had not calculated when he sent that text was what happens when the person receiving it used to spend her days in a law firm reading statutes. Before I tell you what happened the second time we called the police, I need to explain the law that turned everything around. Because this is the law that most tenants do not know, and it is the law that most landlords who threaten retaliation do not know either, or they know it exists and they gamble that you do not. Section 92.331 of the Texas Property Code is the retaliatory eviction statute. It says this: a landlord may not retaliate against a tenant by filing an eviction proceeding, depriving the tenant of use of the premises, decreasing services to the tenant, or increasing the tenant's rent in response to a tenant who has made a good faith complaint to a government entity regarding the landlord's violation of a health or safety code. That is the statute. But here is the part that matters most. The law creates a presumption. If a landlord takes any retaliatory action within 6 months of a tenant making a good faith report to a government authority, which includes law enforcement, the law presumes the action is retaliatory. The burden then shifts entirely to the landlord to prove that the eviction or other action was not retaliation. They have to prove a negative. In practice, that is very hard to do when the only thing that changed between the tenant's status as an acceptable resident and their status as a problem to be removed was a police call made 48 hours earlier. The other thing the statute does, it gives the tenant a counterclaim. If the landlord pursues retaliation and is found to have violated the statute, the tenant can recover attorney fees, court costs, and up to 1 month's additional rent and damages, which means a landlord who decides to retaliate is not just risking losing the eviction case, he is risking paying for the cost of losing it. Most landlords who say I know the law have not read this section, because if they had, they would understand that sending an eviction threat by text message the day after a tenant calls the police is not a smart thing to do. It is a time-stamped admission. I know all of this because I spent my evening after Mr. Vickers' text message reading the Texas Property Code, and what I found, while standing at my kitchen counter with my phone, is the thing that changed the entire situation in less than 1 week. Before I tell you what happened the night Mr. Vickers showed up alongside the police and threatened us, I want you to answer something in the comments right now. Does your state have a retaliatory eviction statute? Leave yes, no, or I have no idea in the comments. Because by the end of this video, you will know how to find out. And that number, whatever it is in your state, is the one you need before you ever need it. The footsteps started about 3 weeks after a new neighbor moved into the adjacent unit. Not building settling sounds, not wildlife. A 2-footed, weight-bearing movement pattern that tracked deliberately across the ceiling and stopped above our bathroom and bedroom. Mara heard it first in the bathroom one evening. She came to get me, and we stood together under the ceiling and listened for about 5 minutes. The movement was unmistakable. She said, "That is someone walking." I said, "I know." She said, "Above the bathroom." We did not call the police the first time. We knocked on the new neighbor's door. He said he did not know of any attic work being done. He was pleasant about it. Then we knocked on the property management office. The maintenance coordinator told us there was no scheduled attic work and that what we were hearing was most likely the HVA system or wildlife. I said, "I have lived in top-floor apartments before. I know what wildlife sounds like in a ceiling." "This is not that," he said. "Open a maintenance ticket if it continues." We opened the ticket. Nothing came of it. The footsteps came back the following week, and the week after that, each time above the same area of our unit, always in the evening, always the same deliberate weight-bearing pattern. We kept notes, dates, times, duration, not because we were planning anything, because it is what I do. 6 years at a law firm conditions you in specific ways. You write things down, you date them, you do not rely on memory for things that may matter later. The notes were a reflex, not a strategy. That reflex is the reason I had a documented record when I needed one. I want to tell you something about the maintenance coordinator who told us it was probably the HVAC. He said it in the specific tone of someone who has said something similar many times before, not dismissive exactly, but certain that the conversation was now over. That tone is a tool. It works because most people, when they are told something is probably the HVAC, begin to wonder if maybe they were wrong. Maybe the building does make more sounds than they realized. Maybe the stress of the situation is coloring how they hear things. That doubt is the intended result. We experienced it. Mara and I spent evenings that winter asking each other if we were perceiving accurately. We were, but the doubt was real and it was exhausting because I spent 6 years at a law firm and keeping dated notes is a reflex by now. Those notes would matter later. 3 weeks into the footsteps, Mara was in the shower when she called out for me in a voice I recognized immediately as not casual. I moved fast. She said she had seen what looked like a camera flash from the direction of the ceiling vent near the shower. I want to be careful here. I know that a flash of light in a bathroom in isolation is not evidence of anything, but a flash of light above a bathroom where we had been hearing deliberate footsteps for 3 weeks was not something I was going to explain away. We called the police. 2 officers came. One of them was a woman I will call Officer Reyes. She was methodical and did not dismiss what we told her. She asked if she could stand in our unit and listen. We said yes. Within a few minutes of her arrival, we all heard it. Movement in the attic directly above us. Officer Reyes said, "I hear that. Is that the neighbor you mentioned?" I said, "He is the one we have seen near the attic hatch in the hallway." She and her partner checked the hatch. Whoever had been moving went quiet. No one was visible from the hatch opening. The space was too large to search with standard equipment. The police report documented what they had heard. It documented our account. It was a record. Not an arrest, but a dated, signed, official record that we had reported a real and specific thing, and that a responding officer had observed something consistent with what we described. After the officers left, Mara and I bought a small wireless camera and installed it in the attic through the hatch. We could not leave it there permanently. The battery required retrieval every few days, but we rotated it in and out. The footage we got changed the situation entirely. There was a device in the crawl space above our unit that was not building infrastructure. It was positioned in a corner above our bathroom area. Near it, a small section of the wooden attic floor had been cut away. The cut was clean, not broken, not rotted, cut deliberately at some point that the wood condition suggested was relatively recent. Mara looked at the footage on the camera screen. She said, "That cut is directly above the bathroom." I said, "I know." We called the police again. Quick stop here because I want you to understand exactly where we are. 9 months of a new neighbor. Footsteps above our bathroom documented in dated notes. One police report with an officer who heard the movement herself. A camera showing an unidentified device and a freshly cut hole in the attic floor above our bathroom. We called the police for the second time, and that is when Mr. Vickers appeared. Here is what happened. He arrived shortly after the officers. I do not know if the neighbor called him or if he monitored police dispatches from the property. He let himself into the common area and positioned himself near the attic hatch while the officers were speaking with us. He said, "These two have been having issues since they moved in. Always something." Officer Reyes looked at him for a moment. Then she said, "We are going to look at the attic. If you own the building, I would like you to be present." He went up with the officers. When they came down, they showed him the camera footage on the small screen. They showed him the device and the cut floor. They asked if he could identify the device. He said he could not. They asked if he knew who had made the cut. He said he did not know. They asked if he intended to investigate. He said it was probably old infrastructure, and that this was the kind of thing tenants who did not understand buildings blew out of proportion. Officer Reyes noted in her report that the device could not be identified from visual inspection, and that the cut in the floor appeared to have been made recently based on the condition of the wood edge. Then Mr. Vickers turned to us. He said that he had been patient with us long enough. He said we would be receiving a notice to vacate within 2 weeks for disrupting the property's peaceful environment. I said, "You are threatening to evict us for calling the police." He said, "I am removing problematic tenants who are creating disturbances for other residents." I said, "The disturbance is in the attic above our apartment. We reported it to law enforcement because we believe it may be a crime. Evicting us for that," he said, "I know the law." He left before I could finish the sentence. I went inside and pulled up the Texas property code on my phone. Section 92.331. I read it 3 times. Then I called Mara into the kitchen and read it to her. I said, "He cannot legally evict us for calling the police. The law presumes the eviction is retaliatory if it happens within 6 months of a good faith report to law enforcement. The burden shifts to him to prove it is not." She said, "He said he knows the law." I said, "He clearly does not know this one." That night, I drafted a text message to Mr. Vickers. I cited the statute by number. I stated that any eviction initiated within 6 months of our police reports would be presumed retaliatory under Texas law. I stated that we were prepared to raise this defense and to counterclaim for attorney fees, court costs, and additional rent as provided under the statute. I sent it. Then I printed a copy and added it to the folder. The next morning, I called a tenant rights hotline run by a legal aid organization. The counselor confirmed my reading of the statute. She said Mr. Vickers would have a very difficult time with a retaliatory eviction case given that we had a documented police report showing that a responding officer had personally observed something consistent with our complaint. I also made 2 other calls that week. The first was to the building inspector's office. I filed a formal complaint about the unidentified device in the cut floor, requesting an official inspection. Whatever the device was, it deserved a professional evaluation, not a landlord who refused to look at it. The second call was to my neighbor on the other side of the new tenant. Mrs. Reeves had lived in the building for 8 years. I asked if she had noticed anything unusual since the new neighbor moved in 9 months ago. She said, "I have heard him in the attic, not once or twice, regularly. I assumed he had some reason to be up there." I said, "Would you be willing to say what you heard, if it came to that?" She said, "I have lived here 8 years. I know what normal sounds like in this building. If what you are describing is accurate, yes." I now had a police officer who had personally heard the movement and documented it. I had 8 years of baseline knowledge from Mrs. Reeves. I had 2 police reports. I had camera footage, and I had a time-stamped text message from Mr. Vickers threatening eviction within 24 hours of our second police call. I found Ms. Delgado through the legal aid referral list, tenant rights specialist. She reviewed everything I had assembled. She said the retaliatory eviction threat is your strongest position. The statute is explicit. You called the police in good faith about a potential crime. He threatened to evict you within hours. That is exactly what the law is designed to address. I said, what about the attic situation and the device? She said, if the device turns out to be unauthorized surveillance equipment, that is a criminal matter for law enforcement. If the landlord knew about attic access and failed to address it, that touches on his duty to maintain a habitable and safe property. But the eviction threat is the immediate issue. A formal letter from my office will clarify his position. The letter went out the following week. It cited Section 92.331 by number. It documented the exact timeline, police call dates, eviction threat date, the legal presumption that attached to that sequence. It requested written confirmation within 7 days that the eviction would not be pursued. It stated we were prepared to raise the defense and the counterclaim for damages if he proceeded. The building inspector came out that same week. He went into the attic with proper equipment and documented everything. His findings: the device was old, abandoned cable equipment, a legacy installation from a previous provider that had never been removed. It was not functional. The cut section of the floor could not be attributed to original construction. The inspector noted the condition of the cut edge suggested it had been made relatively recently, but he could not determine when or by whom. That finding was both a relief and a frustration. Relief because the device was not what we had feared. I had spent weeks preparing mentally for the inspector to confirm that what we found was functional surveillance equipment. Instead, old cable infrastructure, abandoned in place when the building switched providers, sitting in a crawl space above someone's bathroom for years without anyone knowing it was there. I sat with that for a long time, not because it resolved everything, because it raised its own question: how many other abandoned devices are sitting in attic spaces above other people's bathrooms in buildings across the country, and how many tenants have been told they were imagining things when they started hearing footsteps? Frustration because the cut floor, the thing hardest to explain as innocent, remained unexplained. The inspector's report also found that the attic hatch had no adequate lock and was accessible to anyone in the building. He issued a compliance notice requiring a lockable cover within 30 days. 30 days to address the exact thing we had been asking for. 8 days after Miss Delgado mailed the letter, her text arrived. She said they withdrew. No formal eviction. The letter does not admit wrongdoing, but the outcome is what matters. Your tenancy is secure. I sat with that message for a moment. Then I went to find Mara, who was in the kitchen making coffee. I showed her the text. She read it, set the phone down, exhaled. She said, "Okay." I said, "Okay." She said, "We do not have to move." I said, "We do not have to move." Mr. Vickers complied with the inspector's compliance notice. I watched the maintenance worker install the lock on the attic hatch on a Thursday afternoon. From that day forward, the space above our apartment was accessible only to someone with a key. The footsteps stopped. The neighbor has not been heard in the attic since the lock went in. Our camera, which we continued to run through a gap in the hatch cover, has shown no one entering that space. Before I tell you what Mrs. Reeves brought over when this was all settled, I want to go back to the question from the beginning. Does your state have a retaliatory eviction statute? Because here is the thing I most want you to take from this story. Most tenants who are threatened with eviction after complaining about something legitimate simply absorb it. They assume the landlord is right. They assume I know the law is a statement of fact rather than a bluff. They do not look up the law, they start packing. The difference between that outcome and mine was one text message from a statute I found in about 20 minutes on my phone. Go look up your state's tenant protection laws before you ever need them. Search your state name plus retaliatory eviction statute, find the section number, write it down somewhere you can access quickly. The time to find it is now, when you have no landlord threatening you, not later when you have 2 weeks and a moving deadline. Leave in the comments what you found, or if you already knew your state's retaliatory eviction protections. Here are the numbers from this situation. I want to give them to you one at a time. 8 days. That is how long it took Mr. Vickers to withdraw the eviction threat after Miss Delgado's letter arrived. 8 days from a certified letter citing one statute. 8 days from the moment his legal position became visible to him in writing. 30 days, the compliance deadline on the attic lock, the thing we had been asking him to address for months. It took a building inspector and a formal compliance notice to produce what a tenant request could not. 6 months, the protection window under Texas Property Code Section 92.331. Any retaliatory action within 6 months of a good faith government report is presumed retaliatory. Know the window. In your state it may be different, but it exists. 2 police reports, 1 inspector's compliance notice, 1 attorney's letter, 1 text message back. That is the entirety of what it took to protect a tenancy that was threatened because we reported a real problem to the police. 8 years. That is how long Mrs. Reeves had lived in the building before she came to our door with the casserole. She had heard the footsteps, she had heard them for months. She had not reported them because she did not know they were worth reporting. She stopped by about 3 weeks after the lock went in. She brought the casserole without calling ahead, which is the kind of thing people do when they have something they want to say and are not sure how to start. She said, "I am glad you pushed back on him. He does the same thing to everyone who complains, acts like they are unstable." I said, "He tried to do it to us." She said, "I know, but you knew what to say to him. I have been here 8 years and I would not have known to cite a statute at him." We talked for an hour. She had her own history with Mr. Vickers, the dismissals, the "I know the law" line used on her once when she complained about a maintenance issue that had gone unaddressed for 2 months. She had backed down. She had not known she did not have to. What I had done differently, she said, was look up what the law actually said. She said this not as a compliment exactly, more as an observation about the gap between what tenants are entitled to know and what most of them actually know. Most tenants do not know their state has a retaliatory eviction statute. Most tenants do not know that calling the police in good faith creates a legal protection window. Most tenants, when a landlord says, "I know the law," stop talking. Mrs. Reeves had stopped talking for 8 years, and she was right. That was the whole thing. Not cleverness, not connections, not money for attorneys. Ms. Delgado's initial consultation was through legal aid, which was free. The difference was 20 minutes with a statute on my phone the night Mr. Vickers sent that text. I want to be honest about one more thing before I close. Mara and I are planning to move when the lease ends, not because we lost, we did not lose, but because a building where the landlord's first response to a real problem is to call you crazy, and whose second response to being challenged is a retaliatory eviction threat, is not a building I want to spend more time in than I have to. We are moving on our schedule, with a clean record, with no eviction on our history, and with a very specific piece of knowledge about how the Texas Property Code works that we will carry to every lease we sign from here forward. Mr. Vickers communicates with us now through the property management portal. He gives required notice before any maintenance. He does not use the phrase, "I know the law" to us anymore. Whether that is because he has reconsidered his approach or because he simply calculates that we are more trouble than we are worth to push around, I do not know. Either outcome is fine with me. At the beginning, I asked, if your landlord threatened to evict you for calling the police about a safety problem in your building, would you know what to do? Here is the answer. First, find your state's retaliatory eviction statute before you ever need it. Search your state name and retaliatory eviction, find the protection window. How many months after a good faith complaint are you protected? Write the statute number somewhere accessible. In Texas, it is Section 92.331. In your state, it will have a different number, but it almost certainly exists. Second, document everything with timestamps, the date of your report to law enforcement, the date of any eviction threat, in writing if possible. Screenshot every text, print and date every email. The proximity of those 2 dates is the foundation of your retaliatory eviction defense. In my case, the gap was less than 24 hours. That gap is the whole case. Third, cite the statute by number when you respond to the threat, not as aggression, as information. Under section whatever of the state property code, an eviction within 6 months of a good faith report to a government authority is presumed retaliatory. I am prepared to raise this defense. That sentence in writing with a statute number changes the calculation for a landlord who has been betting that you do not know the law. Fourth, request the official inspection. Whatever the problem is, an unidentified device, a structural issue, a habitability concern, file a formal complaint with the building inspector's office. Not just because you need the inspection, because the official record that results from that inspection exists independent of anything your landlord says about you. He can call you dramatic in conversations with other tenants. He cannot change what the county inspector wrote. And fifth, find tenant resources before you are in crisis. Legal aid organizations, tenant rights hotlines, the referral list for attorneys who handle landlord-tenant matters. Know where they are now when you do not urgently need them. When you do urgently need them, the time to find them has already passed. You are not imagining the things you observe. You are not being difficult for reporting them. A landlord who tells you that you are is making a bet about what you know and what you are willing to do about it. My sister and I proved that bet wrong. You can too. So I want to hear from you. If your landlord threatened to evict you for calling the police about something real, what would you do? And if you already know your state's retaliatory eviction statute number, leave it in the comments. You might help someone who needs it tonight. Leave it in the comments. I raid everyone.